Going Crow. Hi you guys, welcome back. It's been so long since I uploaded my last episode. I've been trying so hard to record this episode. It's such a sensitive topic. So I warned you. 2008, Williams entered a public internet chat room and chatted with an undercover Secret Service agent, offering to send the agent images of his daughter being molested in exchange for other sexual images of children. After the agent didn't share the requested photos, Williams posted a message to the chat room that contained a link, leading to images of 7 actual children between the ages of 5 and 15, engaged in sexual activity. The Secret Service then searched Williams' home. Pursuant to a search warrant, agents found and seized 2 hard drives containing at least 22 images of real children engaged in sexual activities. Williams was charged with 1 count of possessing child pornography and 1 count of pandering child pornography. This court document were found on one of the pictures for Balenciaga's Spring-Summer collection, which was released last year on November 16th. Featured a bag which was designed along with the popular sportswear brand Adidas. The bag was photographed on a desk atop a pile of paperwork. It was meant to give an office chic vibe. What's unusual about this ruling, apart from the fact that it featured in a Balenciaga campaign, is that this particular ruling involved a federal protection that was available against child pornography. In fact, that this case was about whether or not banning child pornography violated the right to freedom of speech about child pornography. It's a completely bizarre thing to deliberately, even though the court document about child pornography was the most obviously disturbing part of the photoshoot. It wasn't the only one. Children shown holding Balenciaga's new line of handbags, fluffy teddy bear-shaped handbags, which were wearing leather BDSM, and their face reactions were too much. Also, the book by the painter Michael Borman's painting as containing depictions of toddlers engaged in playful but mysterious acts with sinister overtones and insinuations of violence. These are just a few examples of Borman's painting, which clearly focused on naked toddlers who appear to be on some sort of a stage or a set and are surrounded by disturbing scenes of blood. Balenciaga has not released an explanation for showing Borman's work in the same campaign as child pornography documents. Balenciaga has always been a brand known for runway shows that push boundary and make audiences uncomfortable. The right word to describe it is the weird and abnormal clothing brand to attract attention, like sending runway models walking through snow and mud. Can't imagine they put $2,000 price on a pair of destroyed sneakers. However, this particular campaign have caused more outrage. I remember #CancelBalenciaga started trending. Public accusations spread like wildfire. People were destroying Balenciaga purses, shoes, and other luxury products on social media in protest of this campaign. Mostly aimed at the brand's creative director, Balenciaga was accused of promoting pedophilia and behaving inappropriately toward child models who would have no idea what the outfit or the bears meant. Now, this was undeniably bad. The press was terrible, and for a brand that outfits so many high profile. And Balenciaga claimed that they did not notice until the images were published, despite the photoshoot taking place months before the backlash. For such a high-profile designer brand, this shows astonishing lack of attention to detail. When you were selecting the perfect shoot out of hundreds, how could you fail to notice 4 references to child sexual abuse? Having, sharing, or selling child pornography is illegal as a general rule, and what happened in that campaign is literally a crime. But looking more, if those children weren't real, will it still be a problem? Let me explain to you some terms. Child pornography, meaning sexually explicit images of actual children, is criminalized because of the harm it does to the children involved, and so its possession and distribution. But virtual child pornography, involving computer-generated images of children or adult actors made to look like children. And guess what? It is a protected speech because the harm to children rationale doesn't apply. Yeah, you got it right. Virtual child pornography is a protected free speech under the First Amendment. How crazy is that? It all started with Free Speech Coalition, a group associated with pornography. It's a non-profit trade association representing the porn industry at large, in particular in the United States. The name might say free speech, but in actuality, the organization has fought for the legalization of child pornography. In Ashcroft versus Free Speech Coalition, the US Supreme Court held that the government may not criminalize such action because the production of virtual child pornography does not sexually abuse an actual child. The court rejected the government's argument that virtual child pornography encourages pedophiles to abuse children. This argument is the intellectual equivalent of a claim that Romeo and Juliet encourages teenagers to kill themselves and should be banned from high school reading lists. The Free Speech Coalition Court believes that the alternative of legal virtual child pornography would reduce the production of actual child pornography because people could not be punished for the creation or possession of this. The Ashcroft Court essentially decided that if a child pornographer could choose between abusing a child and digitally creating a virtual one, he would almost always choose the latter. If virtual images were identical to illegal child pornography, few pornographers would risk prosecution by abusing real children. Many experts on child molesters explain that these individuals derive sexual gratification from the pain inflicted on actual children. Child pornographers do not abuse children for the primary goal of making child pornography. Instead, abusing children is an activity that child molesters like to take part in. Recording that abuse is something else that they like to do. Being given an alternative means of creating child pornography would not make a child molester stop abusing children. This argument that the Supreme Court puts forth is akin to saying the following. A boy likes to skateboard with his friends. He enjoys films himself perform skateboard tricks. He then likes to go on a computer and trade his videos with other skateboarders to view their videos and enjoy. If at some point technology came around where it was easy and efficient to produce those same skateboarding videos, but without actually having to skateboard, it is the court's opinion that the boy and others like him would almost always choose the alternative method. But the court is missing the main point. The boy likes to skateboard, so even if he was given other means of producing a skateboarding video, he still is going to skateboard. Same logic follows with child molesters. Child molesters have a propensity to molest children, and they derive pleasure from recording the abuse. So even if they are giving another means of producing videos of children being sexually molested, they are still to molest children. Another reason for why Ashcroft was incorrectly decided was that the court's reasoning was inconsistent with Osborne and Faber, because the court in Ashcroft changed its view on indirect harm. In Osborne case, the court found that pedophiles will sometimes use child pornography to help seduce other children into sexual activity. Therefore, it recognized that the fact that there were two types of harm stemming from child pornography, direct and indirect. The Osborne court was aware that child pornography not only caused direct harm to the children who were used as subject in the pornographic material, but also caused indirect harm to other children. Because virtual child pornography is virtually indistinguishable from actual child pornography, it causes the same indirect harm to children as actual child pornography does. When a child views a video of a similarly aged child engaging in sexual activity with an adult, the child sees this activity as being acceptable and thus is more willing to engage in sexual acts with the pedophile. These pedophiles are used this child pornography in order to make the child feel comfortable in turning their relationship into a sexual one. What the court in Ashcroft failed to understand is that from the perspective of the child, he could care less whether the image is of a real or virtual person. To the child, it makes no difference if a pedophile was using a cartoon such as SpongeBob SquarePants to seduce a child, that SpongeBob should now be prohibited. But Congress found that when child pornography is used as a means of seducing or breaking down a child's inhibitions, the images are equally effective, regardless of whether they are real photographs or computer generated. In 1995, Congress opined that apparent child pornography was equally as dangerous as real child pornography. Yet technology back then was not even a fraction of what is today. Justice Thomas conceded in his concerning opinion in Ashcroft that technology may evolve to the point where it becomes impossible to enforce actual child pornography laws because the government cannot prove that certain pornographic images are of real children. Majority in Ashcroft failed to address Congress' concern that computer imaging technology is making it increasingly difficult in criminal cases for the government to meet its burden of proving that a pornographic image is of a real child. The absence of congressional action, the difficulties in informing the child pornography laws will continue to grow increasingly worse. The prospect that technology exists to create composite of computer-generated depictions that are indistinguishable from depictions of real children will allow defendants who possess images of real children to escape prosecution, for it threatens to create reasonable doubt in every case of computer image, even when a real child was abused. This threatens to render child pornography laws that protect real children enforceable. Think about it. This future time period that Justice Thomas speaks of, it's upon us now. It has been 21 years since the court decided Ashcroft, and in that time, technology has improved tenfold. At the time of Ashcroft's decision, Congress had evidence demonstrating that technology already exists to disguise depictions of real children, to make them unidentifiable, and to make depictions of real children appear computer-generated. No need to look any further than the items in our own homes to realize how much technology has progressed in the last decades. In the world of gaming, using motion capture technology and state-of-the-art CGI technology to give us the most lifelike humans today. And in Hollywood, you have movies such as Interstellar, Dune, The Curious Case of Benjamin Button, which used CGI technology to create what looks to be the most realistic depiction of these words. As technology has progressed, We are rapidly approaching a point where virtual images and videos are nearly indistinguishable from their real-life counterparts. In the realm of child pornography, this poses a dangerous and difficult problem. With the existing of AI now, child AI porn desperately needs to be refuted. Simulations of child pornography aren't victimless, even if we ignore the obvious degradation of the person watching and the AI-generated child porn and the person who made it. There are real children who are being exploited behind each computer-generated image. Yes, predators use real videos and images of child exploitation to train AI programs to create more content. Moreover, predators often use social media images of children to create deepfake lookalikes for their perverse programs, which is enough to give any parents pause before they post images of their children online. So while the actual video may not be a real child suffering abuse, the AI program learned from real videos and uses the faces and likenesses of real children. It said that 80% of respondents in a 3,000-person dark web profile admitted that they had or intended to use AI tools to create child sexual abuse images. AI porn is becoming so prevalent, in fact, that it could soon overwhelm attempts to find real victims from clues left by video footage. Pornography rewires viewers' brains based on the videos they see. As Norma Dwidge of Columbia University puts it, pornography, by offering an endless of sexual objects, hyperactivate the appetitive system. Here, it changes how a person sees other people, especially when young children view this material. AI-generated child pornography is sophisticated and has the same effect on viewers' brain as real porn. It can stimulate in users the same addictive descent into more and more graphic material. Even if images of child pornography don't show real children, it still puts future children in harm's way. The National Center for Missing and Explicit Children condemns AI-generated child pornography as a horrible societal harm because of its links to real child abuse. Such content normalizes the sexualization of children and their abuse. Simulations of child sex abuse are just the beginning of what unregulated, predatory use of AI programs will create. Amazon, Instagram, and Wish have come under fire in recent years for allowing sellers to advertise sex dolls that approximate the size and features of children. If AI can create simulations of child pornography, it's not a stretch for such technology to animate sex dolls or robots with a child's voice or vocabulary. It's time for that to end. AI-generated child pornography isn't a solution. It's just the latest reminder of how much more advanced technology is today than it was in 2002, and of how much more we know about the way pornography, real or AI-generated, hurts its victims and its users too. Giving these changes time for Congress to once again consider measures to regulate the porn industry, starting with his latest AI-generated child porn, safeguarding the physical and psychological well-being of minors and preventing the sexual exploitation and abuse of children constitute a government objective of surpassing importance, then it needs to overturn its decision in Ashcroft. The only way to close the distribution network and dry up the market for child pornography is for the court to no longer distinguish between actual child pornography and virtual child pornography, but instead prohibit both. Just like real child pornography, Virtual child pornography has little to no social value and thus has no place in a society as advanced, as civilized as the country. So the court should classify virtual child pornography as a category of material wholly outside the protection of the First Amendment. Thank you so much, guys, for listening to the episode. I hope you like it, and I really hope you get to raise your voices over this because it's so important to get to the right side of it. Thank you again for listening. Bye.